Anil ji, thank you very much. Yet another pleasant task to share the brief profile of Mr. Anil Goel, who is also a chartered accountant and founder and chairman of AAA Insolvency Professionals LLP. Mr. Anil Goel is known to everyone in the insolvency circle because he's been very active since the inception of the court. He has been on the advisory committee of IPA of ICAE till March 2020, and he has also been the co-chairman of ASSOCHAM National Council for Insolvency and Bankruptcy till March 2021. He was also a member of the working group established by the Insolvency and Bankruptcy Board of India for implementation of individual bankruptcy in India. Also a member of SEBI group as constituted by IBBI for interaction with SEBI, NSE, and BSE for seeking concessions for companies under insolvency process. Acting as faculty for awareness program launched at the instance of CBDT and IBBI for tax authorities. Also a guest faculty, you'll find him spreading knowledge in almost every and each forum, including the DRT, AAICA, and various other institutes, the bodies of the institute, the IPAs, the Insolvency Bankruptcy Workshops, SBI Academy, GIP, all the Chamber of Commerce like CII, PHT, IICA, FICCI, ASSOCHAM. And we always see his articles, which are, quite in vogue. He has been into the insolvency space right from inception, presently acting as liquidator in 10 companies. Some of the known names are REI, Agro, Rotomac group of companies, LML, etc. And he has got, his team spread across the country with 32 designated partners in his entity and 12 associate partners. All of them are handling a lot of insolvency related assignments, and the list goes on and on. In fact, we know C. Anil Goel ji as a very humble person, always available, always willing to help other fellow professionals on every queries relating to insolvency. That is how I know him. I thank him very much to again giving his consent for gracing the occasion as the one of the key speakers in the subsequent topics, which I'm sure is a very practical topic, and I'm sure that his deliberation would help all the participants present. Over to you, Anilji, and thank you very much once again from ACAE.
Thank you very much, Sumit Bhai, my friend. Is there an echo? No, I think it's okay. I think my greetings to CAV Vivek Agarwal, the convener of this study group, IBC committee, Mr. Jatinder Loya, the chairman of the IBC committee, and of course, Mr. Anup Sangai. All distinguished professionals who are attending this webinar today. And I'm humbled to see that maybe the capacity of this platform is only 500. So we can only see something like 500, 499 kind of figure for the last. And then it is also live on YouTube. Maybe that a lot of people are interested in this subject. That's what I feel. So the task which has been given to me by Sumitji is how to fast track the liquidation processes. This was something which for the first time I concentrated and I prepared some contents for this. It's like I was also thinking, I'm presently liquidator in 10 companies. So how to get rid of these 10 companies? Because wherever I apply for any new assignment, these 10 companies are the hindrance. Everyone says that you're overoccupied and you should not take any other assignment. And in some of the banks, I even become ineligible because of these 10 liquidation assignments. So this subject, in fact, so I concentrated, studied a lot, and found a lot of ways to come out of the liquidation processes in a fast track manner. There are some things which are general as a kind of guidance to my fellow co-professionals. And there are some which are new ideas that I'm going to kind of launch today, which I think would be acceptable to the profession as such. Before I, in fact, let me share my screen. It will take a second. Yes. So, as I said, this subject is very new, and for me also, for the first time that I'm presenting this subject. Before even I go for, because my subject is the dissolution of corporate debtor. First, let all of us understand what are the provisions in the code and in the regulations regarding the dissolution of corporate debtor. The first is section 54, which talks about dissolution of corporate debtor, where the assets of the corporate debtor have been completely liquidated. So the first condition is that completely liquidated, and I believe the completely liquidated also in some cases may even include, or NCLT would accept, written off. So in some of the dissolution orders, I believe that the liquidators have said that for other assets, as per the asset memorandum or as per the financial statements, are not recoverable. So we are writing it off. So completely liquidated, I think it also should mean the written off as not recoverable. Then an application is supposed to be made to AA for such dissolution. The AA shall, by an order, dissolve the company, and that would be the last day for the company's life. And within 7 days, the liquidator is supposed to inform to the authority with which the company has been incorporated, like ROC. There are some regulations, and the first regulation is Regulation 5, Sub-Regulation 1. The liquidator shall prepare and submit a final report prior to dissolution. Sub-Regulation 2 says that the liquidator shall preserve. I think Mr. Jitendra Lohia asked me a question, so I think that question comes automatically. So I would also be able to answer that question right away. The liquidator shall preserve physical as well as electronic copies of the reports and minutes referred to in subsection 1. So when I see the sub-regulation 1, that is required to be maintained for 8 years after the dissolution of the corporate debtor. And these reports are preliminary reports, asset memorandum, progress report, sales report, minutes of the consultation committee meetings, and final report. These are the items which are mentioned in sub-regulation 1. So these are required to be maintained for 8 years. So there is no doubt about it. Then we go on to regulation 6, sub-regulation 2. The liquidator shall maintain the following register and books as may be applicable in relation to the liquidation of the corporate debtor, and shall preserve them for a period of 8 years after the dissolution of the corporate debtor. Now let us understand what are these registers and books of books. So when we go to regulation 6.2, so these are all the books, registers, whatever we are supposed to maintain during liquidation process, and it doesn't talk about any books of account of the company or records of the company or records of the litigation prior to the liquidation commencement date. So therefore, the legal requirement as such, I think the answer to Mr. Jitendra Lohia is that the legal requirement is that we are supposed to keep all the reports for 8 years, and we are supposed to prepare and keep all the books and registers. And in case you would see books and registers, there are too many. Like we need to have a cash book, ledger. We actually have to claim register, the litigation register. So regulation 6, sub-regulation 2 talks about 18 books and registers which are required to be maintained. So those all are supposed to be required. Now, what other records are required to be maintained or stored for, and then for what year? Now, let us say that the company is being dissolved, saying that there is no other asset which is available. The company is being dissolved, saying that there is no other asset which is remaining unsold or to be liquidated or to be realized. Then I don't think there is any requirement of keeping any records. To be very cautious, to be on a very cautious scenario, we can actually say that yes, some records of those kind of assets which we sold, that can be kept, and all other records, vouchers, books of accounts, all other details are not required. See, when the company is being dissolved, there is no possibility of any kind of litigation in future, which might even be faced by the liquidator or by the company, because the company is not in existence. However, there may be some inquiries to the liquidator regarding the process. So for the process, the liquidator would be required to maintain all these books and registers. I somehow feel that there are only few liquidators who are maintaining all these 18 books and registers, for which the formats are given in the regulations. And it is important that we should maintain all these books and registers wherever, to whatever extent it is applicable. These are the books of account which we are supposed to maintain for 8 years. Any investigation by IBBI, any investigation by any other authority, they would definitely ask these things from you, but nobody is going to ask from you any records of the corporate debtor, vouchers of the corporate debtor, litigation details of the corporate debtor, income tax details, income tax assessments, company's law records of the corporate debtor, because the corporate debtor is completely dissolved and is not existent. Only for the precaution that we can do. So my subject today is like fast track dissolution of the companies which are under liquidation process. Regulation 14 also provides early dissolution regulation, which you can even sense when you are preparing a preliminary report. When you think that the assets of the companies are not even sufficient to even to cover the cost of liquidation, then you can even file an application to the adjudicating authority for early dissolution of the company, and the necessary directions will be issued. That's what is the early distribution. Then there is a provision under regulation 38, and that provision talks about the powers of the liquidator, that when some of the assets are not being sold, assigned, or transferred. This assigned word was added when the regulation 37A was inserted, and at that particular amendment also the assigned word was inserted. So if the assets are not being sold, assigned, or transferred due to some kind of peculiar nature of the asset, then that asset, with the permission of the adjudicating authority, can be transferred, can be distributed to the stakeholders. So that's what is regulation 38. So this is a kind of a residual section, that in case we are not able to do anything, then we can distribute the unsold assets, unassigned assets, and which are not able to transfer, those can be even distributed to the stakeholders. This I thought that I must list it, because in case before the distribution, in case we find that there was a claim, and after that claim that person has never approached for distribution, and he never gave us the bank account where the distribution is supposed to be reaching, that money has to go to the corporate liquidation account, which is maintained by IBBI, and then only the dissolution would be possible. And this is called unclaimed dividends, which are supposed to be deposited with the IBBI, and the IBBI will take that deposit in corporate liquidation account, and that corporate liquidation account has its own usages. And finally, how can they dispose of? Finally, that money will actually go to exchequer, I believe. Now, I think the completion of liquidation, we actually have to see two things which are very, very important. Regulation 44, sub-regulation 1. It is supposed to be completed within 1 year, and it is written notwithstanding pendency of any application for avoidance of transactions under chapter 3 of part 2 of the code. That means that in case any application is pending under section 43, 45, 49, 50, or 66, those applications, even if those applications are pending, the liquidator can apply for completion of liquidation. But then the question is not answered, who will handle those applications and in what capacity? That question is not answered, and we are trying to find out that answer today. How this pending avoidance transaction applications can be handled when the company goes into dissolution. Because these avoidance applications can even take a little longer. That's what we expect so far. In case the company is being kept as a going concern, so all this period where the company is being kept as a going concern, and then that period would be excluded from the period of 1 year as provided in Regulation 44A. Normally it is 90 days, but there are companies where the company is being kept as a going concern for even more than 90 days. Then Regulation 44(2), it also says that in case the liquidator is taking more than 1 year, so he has to apply to the adjudicating authority for extension, specifying the time limits, specifying the reasons and why the additional time is required. Final report is supposed to be submitted under Regulation 45, and that final report would be for the closure of the asset, and the liquidator has to give how much liquidation cost was incurred, how many assets were sold, what was the recovery, what was the variance between the recovery, variance in the liquidation cost, and finally, so in case the company is sold as a going concern, then this will be an application for closure of the liquidation process. And in case the company is being dissolved, then it will be an application for dissolution. So that's what is the where the mandate of selling the corporate debtor as a going concern comes. Now, let us now understand, these are the basic principles where we actually have noticed two things. One, that despite avoidance applications pending, the company can be dissolved. We have also noticed that the assets can be transferred or distributed to the stakeholders for early dissolution. So the two things that we have noticed, and this is we need to remember, because we actually go ahead for faster closure of the liquidation process. So the first is like how do we assure faster sale of assets? So my experience of handling my own cases and my partner's cases is like 45 liquidations. And we have seen maximum times the hurdles that we face is inappropriate valuation of the assets. So I suggest that the valuation of the assets should be very, very careful. It should be based on the market feedback, and the valuer should be told and given complete information regarding the challenges, titles, possession, permitted alternative uses, etc. So in case the liquidator is stuck with the unrealistic valuation, and it will actually be wasting a lot of precious time. Although it is not stipulated in the regulations that we have to take approval of the stakeholders consultation committee for fixing the reserve price, but the financial creditors, the banks and financial institutions are expecting nowadays that the liquidator should come to them, consult to them regarding the reserve price, and before any reduction is announced or before any reduction is implemented in the reserve price, that also should be consented by the SEC. That's the kind of trend is going on. So this is the practice in the market, that this SEC would resist in the reduction of reserve price. So when we find finally that the valuation was absolutely inappropriate, and in case we try to tell that we should get a second valuation, that is also questionable. And in case we try to reduce it by 25% and then 10% on each auction, that might even take a longer period. So therefore, like whenever we try to get a second valuation after failing in 3 or 4 attempts, that also should be consented by the committee, stakeholders consultation committee. The other thing is that the liquidation assets can only be sold in case we have proper infrastructure, specialized asset sale team, because the CIRP team and the asset sale team, these are two different
Anilji,
yes, please.
Anilji, I just wanted to, just add on to what you just mentioned about the second round of valuation. And this would be an interesting piece of information. So I take your permission to just
absolutely.
give my views.
Yes,
sir, in Gujarat Tanari Coke Limited, and I'm quoting this because this is public, after 3 years of liquidation, nothing was sold for litigations, etc., which is on record. So we went to National Company Law Tribunal, and we had also done the valuation when the liquidation commenced in 2018. So after 3 years, in 2021, when we wanted to put up the assets for sale, definitely the value of the asset, which was valued 3 years prior to the sale into 2021, would have changed due to efflux of time. right?
Yeah.
So we took the permission as you suggested from the stakeholders. The stakeholders granted that yes, you should go for a fresh round of valuation. And when we went to NCLT Kolkata rejected the application, stating that there is no provision in the law for going for second round of valuation. And hence they rejected the application. And they also said that liquidation process prescribes for 25% reduction and 10% reduction. So valuation would take more time, 3 months. So in that process, you can go for 25% reduction. So our advocate said that, okay, my lord, can we straight away reduce 25% and come up with the first reserve price on that basis? That also NCLT rejected. They said that no, you follow the process regulation. So this was just a piece of information because there was a specific order passed. Yeah.
No, I'm also apprehensive that this second valuation is questionable. That is the reason that I said that one has to be very, very particular about when we're getting second valuation. So the most important suggestion that I'm going to give here is that while you are getting it valued, you should be associated with the valuers. You must see whether the valuers are actually keeping doing their job properly or not, whether the proper numbers are being counted, whether the proper titles are being seen. All this is very important because later on it becomes very difficult for the liquidator. It actually simply becomes wastage of time. The stakeholders consultation committee should also be always with you because that actually will protect you from various negativities of the liquidation process. The various kind of allegations which might come to a liquidator, the stakeholders consultation committee minutes of the meeting will protect you. So most of these sensitive items should be discussed in the stakeholders consultation committee meeting. So therefore, sharing of information, transparency of the information, even the sharing of the leads after the assets are sold, that's what we are doing. So most important is like in case we win the trust of the stakeholders consultation committee, they provide consent for further reduction in the reserve price and the assets can be sold in quick succession. Some of the precautions that we need to take for so that our time is not wasted, and that's what I'm saying. The asset must be described properly in the e-auction document with all disclosures, limitations, challenges, local dues, etc. Otherwise, this may lead to even disputes with the auction buyer. The leasehold rights, in case we have a leasehold land, we cannot say that we are selling land. We have to say that we are only selling leasehold rights, and we need to see very carefully whether the leasehold rights are transferable or not. So in case of the state-owned or central government-owned land development agencies, then the leasehold rights are generally transferable, or some builders also. But mostly like the private transactions of the leasing of the land, and then the construction is done by the company, the land is owned by the promoter. So all these lease transactions normally doesn't have that sale of leasehold rights. So then in that case, it's very difficult to sell the leasehold rights, even if the lease is for 99 years. So we are facing difficulties. So in some cases, like in the sale notices, in case you say that we are selling land, that actually will become totally inappropriate that we are selling land. No, we are not selling land. So similarly, the proper number, proper area, proper the building area, the numbers of the plant and machinery, everything, then the stocks, equipment, the segregation of inventory is all very, very important. And in one case, I suffered because the KYC of the bidder, that also should be seen. We have experienced that some bidders, they just join the process to finally surrender in favor of the others. This is one thing that you need to be very careful, because that is called cartelization. And you have power under the regulations that in case you see that there is a cartelization, then you can cancel and you can apply to the adjudicating authority that I sense and there are evidences of cartelization. So therefore this bidding process may be cancelled. Some bidders also participate in 2 or 3 names just to give a sense of fake competition. In real estate transactions, we've seen that in some cases the lease of the land is cancelled by the development agencies or by the lessors. in all those cases where even the sale rights are available during CIRP or before CIRP, that is a very difficult part. So if they cancel the lease rights, again, then we actually have to go to the Gujarat Urja case, and we have to fight it in the NCLT. Then in some cases, the cancellation of the lease by land development agencies or the lessors without sale rights, so or without assignment rights, that also becomes, in case there is no sale right and the lease is also cancelled, then probably you have no asset. As a liquidator, there is no asset available unless you get this cancellation revoked. So that is also a litigation taking and consuming a lot of time. Attachment of assets by civil authorities like tax departments, etc. And that, of course, we have to go to NCLT for getting it detached unless in case the departments are not listening to us. Attachment of assets by investigating agencies under the criminal offenses like PMLA or economic offense wing or CBI or enforcement directorate, narcotics, prevention of corruption. All this is like before the CIRP or after, before the CIRP or during CIRP. This matter is still not resolved. We have something like 7-8 companies with us where all the assets are attached by either economic offense wing or by the enforcement directorate. We are unable to get the relief so far. We got orders, but the enforcement directorate is getting it stayed from different high courts, and those matters are pending with high courts. So these are the challenges in the real estates. So the cancellation of the lease deed against the financial lease transactions, because there are two possibilities of cancellation of lease. One is the technical non-compliances, and the second is non-payment of dues, like the financial non-compliance and technical non-compliances. As far as the financial non-compliances are concerned, that is a matter which can be handled by NCLT. But in case the technical non-compliances are concerned, that of course cannot be handled by NCLT. That you have to go to the respective land development agency or lessor for compliances of those technical requirements, and then finally getting the cancellation as revoked. Then the assets owned by the CD given to other against valid lease. We haven't found any provision where the assets are owned by the company and it is given to lessee and the lease is still valid. And see, we have seen under surface, even the Supreme Court has held that the lessee's rights are to be protected. So there is nothing which is provided in the insolvency law also that if you are a liquidator, you have a right to evict all the lessees, all the tenants. Had it been so, I believe in Kolkata, Delhi, Mumbai, old areas, old city, there are hundreds of buildings which are occupied by multiple tenants. And in case the insolvency is the key, then everyone can go to the insolvency law and all the tenants can be evicted and the building can actually fetch thousands of crores of rupees. So that's not the law. The valid tenancy would continue, and whatever you want to sell, you have to sell along with the rights of the tenant. Assets owned by the corporate debtor given to others on lease and the lease is expired, that of course you have the right to to ask for the eviction. You can go to NCLT or you can go to the other court. I will actually come to the jurisdiction issue because this is also a very important issue, which is a big hurdle for the liquidators, and that's a special coverage that I'm doing today. Assets owned by the company and given to others on lease as sham transaction, and we have seen that the most of the promoters, they actually enter into kind of sham transactions of the lease along with their associate concerns with the related parties, and some of the loans are also converted into loan cum lease agreements. Then they say that it is a lease hold, and the promoters will say that the possession is not with us, and the lessee resist in taking the possession, and that it is actually very difficult to sell those assets while the occupation is by some of the associate concerns. Assets with disputed ownerships and subject to determination by any court or authority, this is also a hurdle. Now, the intangible assets like owned by the corporate debtor, and for example, the company entered into an agreement to sell, and part of the money was paid, and the rest of the money is not paid, and it is an asset of the company. It is an intangible right. It's a contractual right, which that asset can be purchased by making balance payment. So whether that can be sold or not, that's an intangible asset, and also in case the company has booked some properties in with the builders, so that there is a specific performance right. So those specific performance rights also has to be exercised so that the value is realized. So there's various issues. So actually the regulation 39 deals with the main issue, that is the recovery of monies due, and it reads like liquidator shall endeavor to recover and realize all assets of and dues of the corporate debtor in a time-bound manner for maximization of the value of stakeholders. Some of the illustrations are debtors, receivables against the sale of the company, sale of the products or services of the company, loans and advances given for supplies or other loans, claims of refund from statutory authorities or pending insurance claims, security deposits with the various departments or with some suppliers or customers, earnest money deposits with some departments, retention money against some performed contracts or completed projects, deposits against default, deposit against default, like there is in some of the contracts there is a default liability, and since you have performed the contract, so in case there will be any default in the next 3 years, you have a liability. So there are deposits taken by the government agencies, by the local authorities, and that deposit is also an asset for the company, deposit against after sale service or warranties. Performance bank guarantees are also an important asset because the performance bank guarantee, when we do the liquidation, the banks file their claim as a contingent claim because the performance bank guarantee is outstanding, but it is not invoked by the beneficiary because the contract is successfully continuing and there is no after sale requirement, there is no default liability, and it is somehow complying with the project conditions of the project. So the performance bank guarantee is outstanding. Bank has filed a contingent claim, but during the liquidation or maybe after some time, the bank guarantee, performance bank guarantee will expire. When the performance bank guarantee will expire, so that margin, of course, the margin will be taken over by the liquidator even at the commencement of the liquidation. But then that is also something which may get invoked or that may not get invoked. So that contingent claim of any bank, that actually can be then real claim, and then the list of creditors also has to be modified, and also the distribution would be accordingly modified. Claims or refunds or contractual rights or recovery rights pending in litigation, legal suits or arbitration. Some of the cases filed by the company under section 138 of the Negotiable Instrument Act, where some possibilities of recovery. Valid performance bank guarantees I've already said. Contractual rights against franchisees, other licenses of trademarks. Then a recovery from investments which are not readily realizable. For example, investment in joint venture, investment in private limited companies, subsidiary companies, associate companies, partnership firms, shares of those listed companies for which the trading has been suspended. So all these are assets and may mature and may convert into some value at any point of time. Other investments where the documents required for sale or redemptions are not available, any asset or amount which may be recovered from any application for avoidance transaction. Now, avoidance transaction, in case you see section 43, 45, 49, 50, 66, you would see there are various remedies available in those sections. And when we file an application, there is a possibility that the transaction can be reversed for undervalued transaction and the asset can come back to the corporate debtor. Second remedy is that the difference is paid by the buyer. Similarly, some contribution is made by the promoters against section 66 fraudulent transactions. Section 49 also says that the intent of the undervalued transaction, so that also can bring some compensation to the company. Similarly, some preferential transaction where the creditor who got benefit may return some money, and so that it is distributed according to section 53. So all these are assets of the company which actually would be pending while you are trying to dissolve the company. The challenges that we face for all these monies, dues, or realizations. Like one is the lack of information, the other is the non-cooperation from the promoters or the key managerial personals. Time-consuming and the complex litigation. Sometimes even the litigation includes a lot of expenditure, including court fee for recovery. Application of the limitation law is also a difficulty. And the biggest difficulty that now we have faced is Honorable Supreme Court judgment in the case of embassy property developers, which has further caused difficulty to the liquidator. So I would actually say, I think the embassy, this is an issue of jurisdiction. In the embassy case, the Supreme Court has talked about what NCLT can do and what NCLT cannot do. So not that everything actually will come to NCLT. So there were some observations, and based on those observations, the most of the NCLT or NCLAT, they have started passing the orders that the recovery of dues, specific performance, eviction from tenancy is not under their jurisdiction, and the liquidator or the RP is supposed to go to the relevant or other jurisdictions. Now, when we talk about this jurisdiction, I would like to say that section 60 subsection 5 talks about the jurisdiction, and subsection C says any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings. So this recovery of dues, it's all a part of the liquidation or resolution. Eviction, all part of the liquidation or resolution process. So to my understanding, it actually is covered under the jurisdiction of NCLT. Then we also come to the section 63 with the civil courts not to have jurisdiction. Regulation 44 says that we have to complete within 1 year. So in case we have to go and take rounds of all the courts in the country based on various locations of the assets or disputes, so maybe that the liquidator is supposed to go to various courts in the country in case it has to recover money, or it has to get some evictions, or it has to get some arbitration. So that, of course, is not possible under the liquidation processes, which is supposed to be finished in 1 year. Intent of the legislature was not there. No, even the intent of the embassy was not there. The bar of jurisdiction, no civil court have jurisdiction in respect of matters. So all this is very, very clear that this kind of intent was not there. Now let us understand what exactly Embassy Property Developers Private Limited versus State of Karnataka said. That was a case under this that was a case dispute arising under the Mines and Mineral Development and Regulation Act, MMDR Act, and that was the dispute was with the state of Karnataka. NCLT being the creature of a special statute for discharging certain specific functions cannot be elevated to the status of a superior court having the power of judicial review over administrative action. Supreme Court further observed that a decision taken by the government or statutory authority in relation to a matter which is in the realm of public law cannot be brought within the fold of section 60 subsection 5. So the very, very important word that they used is the public law, which is in the realm of public law cannot be brought into the fold of section 60 subsection 5. Then when this when this order came, this was on 3rd of December 2019. So immediately after this, on 28th of December, this particular amendment was made to section 14, subsection 1 of IBC, where it was clarified that a license, permit, registration, quota, concession, clearances, or similar grant or right given by the central government, state government, local authority, sectoral regulator, or any other existing legal authority shall not be suspended or terminated on the grounds of insolvency. So this was added as the one situation. So in some people, they also say that this was only for overruling the embassy property development. So this particular ordinance immediately came, which is immediately within 1 month. Now look at this the impact of this embassy judgment in asset reconstruction company versus Precision Fasteners. It is held by NCLAT in October 2020. that the jurisdiction of adjudicating authority does not extend to subjects like recovery of money, specific performance, or fiction proceedings, which were to be dealt by civil courts only. It is to be borne in mind that on the guise that the Insolvency and Bankruptcy Code is a complete code, and adjudicating authority can neither enlarge or amplify its jurisdiction. Then let us see what exactly this KL Jute Products Private Limited, it again like on the eviction of tenancy, and this is again unclad judgment in February 2020. Insofar as eviction of second respondent is concerned, the adjudicating authority is not empowered to pass an order of eviction, and it is for an aggrieved party to move the appropriate forum for redressal of its grievances in accordance with law. This is what is the present meaning which is being, it is actually seen as if this is the meaning. So when I actually see the meaning is slightly, I see, but however, this actually have seen little bit of reversal when in March 8th March 2021, Gujarat Urja Vikas Nigam Limited versus Amit Gupta, this judgment was given by Supreme Court. The Supreme Court has said, I'm only reading the red text, the primary consideration which weighed with this court while coming to its decision was that NCLT cannot have jurisdiction on matters of public law. So the embassy was applicable only to public law, which was misinterpreted by some some benches and some appellate authority benches. Now let us understand the public law, and it's like in this section in paragraph 37 of this order, it says that the clause C of subsection 5 of section 60, which I was reading a few slides before, is very broad in its sweep. In that it speaks about any question of law or facts arising out of or in relation to insolvency resolution, but a decision taken by the government or a statutory authority in relation to a matter which is in the realm of public law cannot by any stretch of imagination be brought within the fold of the phrase arising out of or in relation to the insolvency resolution appearing in clause C. So one, that it is very broad, but the public law cannot be coming. Now I further researched what is public law. It is very clear that the public law is the law of relations between individuals and state. The part of the law that deals with the constitution and functions of the organs of central and local government, the relationship between individuals and the state, the relationship between individuals and that are of direct concern to the state. The public law are the constitutional law, administrative law, criminal law, and criminal procedure are subject to matter of public law. See, on the contrary, the private law is concerned with the relationship between individuals with one another, or a private relationship between citizens and companies that are not of public importance. So with this scenario, I would now say that what we are talking about is that we are only talking about the recovery of money. We are talking about the disputes of landlord and tenants. We are only talking about the two property owners, the disputes regarding properties which are between the individuals or between the corporate persons. So this is something which is a private law, and all this should be under the jurisdiction of NCLT. I'm not saying that the income tax matters also would be attended by the NCLAT, income tax, excise duty, or anywhere where the one side is the government or any local government. That matter cannot be resolved by NCLT or appellate authority, but wherever the government is not involved, those matters definitely can be resolved by the benches. So like when we talk about private law, I'm also taking some power from the wording of section 238, which are the provisions of this code to override other laws. The provisions of this, I'm reading it very carefully, and the last wording which are in red, the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any such law. Now, instrument it could be an instrument means any document which is executed. So there can be many names of the documents, starting from the shareholders agreement to joint venture agreement to partnership deeds to contracts, all those contracts where it is written that the insolvency would be considered as a default, all that would be overridden by section 238, and the provisions are very clear that any instrument having effect by virtue of any such law, so that also the instrument would also be overridden by the section 238. So it is not only other laws, but it is also the any kind of agreement. So with this also we are getting strength that all these lease agreements or everything is under the process of this is what is considered to be private law, and the private law, all the matters should go to NCLT. So we all have to just consider that wherever we feel that the our recovery of money or the dispute between two parties, two private persons, two business entities, I believe the jurisdiction lies with the NCLT. That's what is the original structure. The liquidator was not supposed to move from court to court and authority to authority unless the other part of the authority is government. Otherwise, everything has to be resolved within the adjudicating authority. And the Supreme Court also says in Gujarat Urja Nigam that it was only for public law, so it was not for private law. The private law is different. Now coming to the fast, how to close, I have now so far what I've done, I have given the so many difficulties that the liquidator might have in real estate assets, disputes of real estate, recovery of money, possession of properties, intangible assets, claims, refunds, deposits, outstanding performance guarantees, receivables, everything is outstanding. One option is that I say that nothing is recoverable and I file an application to the adjudicating authority that these are the actions that I have taken, nothing is recoverable, so I need dissolution. This is one option. I'm not sure the adjudicating authority would pass an order for dissolution or not. And even if the adjudicating authority passes an order, I think the liquidator should have done something better than this. Like this is a very, very easy route to say that nothing is recoverable and we can file an application and give a declaration that I made an effort and I couldn't recover anything, so therefore the company be dissolved. That's option available. So somebody can try that. However, till the time any kind of litigation is pending, this particular option is also not possible. Even if there is one claim pending with NCDRC, either you withdraw that or you have to conclude that. Now the other option which is come up is like Regulation 37A, assignment of not readily realizable assets. This was inserted only on 13th of November 2020. This is very important, and now this actually will lead us to kind of a solution for fast tracking the dissolution of the companies. It says the liquidator may assign or transfer. Liquidator may try assign or transfer not readily realizable asset through a transparent process. So first of all, we actually have to see the transparent process in consultation with the stakeholders consultation committee. I am saying consultation. It is not written as approval. It is only consultation. Even in Regulation 32, even in Regulation 31 also, it is written that the stakeholders consultation committee would provide consultation only on Regulation 32. That is also very important to see that the SCC would have powers to provide consultation only on Regulation 32, that is restricted to mode of sale, manner of sale. Now the explanation say that for the purpose of this regulation, not readily realizable asset means any asset included in the liquidation state which could not be sold through available options and includes contingent or disputed assets and assets underlying proceedings for preferential, undervalued, extortionate, credit, and fraudulent transactions as referred to in section 43(251) and section 66 of the code. So now this is the second time that we have seen that the applications are pending, avoidance transaction applications are pending, and the company can be dissolved. However, there is nothing mentioned in the regulations how to do that. This is the first time that we have seen regulation 37A that is saying that the assignment should be done. Now let us understand how this regulation 37A work. First of all, transparent process. Secondly, consultation with the SEC. These two things that we have to note down. And it also includes all kind of contingent or disputed assets. And the process has to be transparent. How to use regulation 37A for faster closing. My first experience is that no market has so far developed for the purchase of NRRA, that is disputed assets, litigation assets, contingent assets, the recovery of debts, which may take time, assets attached by investigation agencies, or because there is no possibility of evaluation. The valuation is uncertain, recovery is uncertain, period is uncertain. How anyone can come and give us an appropriate valuation, and whatever valuation that person is offering, how that can be a process of transparency, how that SEC would be ready to sell those assets almost free or with a very small amount. Second difficulty is the due diligence by such companies. Such companies means the litigation funding companies or companies who are interested in such kind of acquisition of assets. Due diligence is not possible by them because the very, very stringent, and the liquidators are not having that kind of information, documents, or evidences. The buyer of NRRA would always depend upon the promoters or key managerial personnel of the corporate debtor for proper facts and documents, and that particular assistance or help would not be available. So we are actually not able to buy, we are not able to get any customer who are actually ready to give appropriate valuation for all these NRR assets, and that is the reason that we have to find out some innovative ways how to use regulation 37A and close it. So the process is very clear that first of all, a list of such assets along with the difficulty in selling or disputes or litigation, everything, this list has to be prepared. A detailed list, whatever information that we have along with that information. Collect all documents, etc., pertaining to these assets, whatever would be required for due diligence and pursuing the realization. Valuation of such asset can be taken out from the valuation report, which has already been obtained by the RP or the liquidator. The stakeholders consultation committee meeting should be held. A presentation should be made before the SEC. We need to develop a consensus on the reserve price. Although I already said that it is the power of the liquidator, but of course, if the consensus is achieved, that's better. In case the consensus are not achieved, the liquidator still have the power to put it in writing and still continue with the process of e-auction. In case of liquidation cases where no SEC was constituted earlier, because there are some liquidation cases where the liquidation order came much before the regulation 31A for the constitution of stakeholders consultation committee was inserted. In all those cases, instead of SEC, in one of the case, an application was made to adjudicating authority, and the adjudicating authority gave a very simple order that since there is no SEC, so we permit the liquidator to continue to go ahead with the sale of NRRA by following a transparent process. That was the order given by the adjudicating authority. A detailed e-auction document should be prepared, including the details of the assets, terms of the sale, reserve price, etc. Public notice should be given for the assignment of these assets, and then finally e-auction should be conducted. Now, the first option is that the e-auction is successful and we get somebody who actually is able to give us a price, which is the reserve price. Very good. And so we are clear, whatever assets were there, we have already assigned those assets. An assignment agreement will be made, assignment agreement will be executed, the payment would be made, and the company can be, finally, the application can be submitted. And for this assignment, there is no requirement of even going to adjudicating authority. That assignment agreement should be very clear, and all the rights, all the titles should be assigned to the assignee. In this particular case, the liquidator will act as a signer, and the assignee will take all the rights. So this is one option. So this is very successful use of Regulation 37A. But the other scenario is that in case the SEC doesn't agree, then how do we sell the assets? So in case the SEC doesn't agree, then I think we can file an application to adjudicating authority that these are the circumstances. The stakeholders consultation committee are not agreeing. There is no consensus, and I have to get out of this dissolution, and I have to just fulfill the objectives of the code. And so far there is only 10% liquidation, 10% dissolutions have not been done. So if the liquidation process will continue for years, the objective of the code actually would be failed. So in that case, the application can be made to adjudicating authority. Secondly, as per regulations, in the case of private sale also, we can file an application to adjudicating authority. In case of sale to related party, in case of sale or assignment to a related party, then also an application can be filed to adjudicating authority for approval, and file an application for all suits or proceedings for replacement of assignee's name in the list of parties. After the assignment, the assignee, whosoever has taken over the disputed assets, he would be under responsibility to file an application to all those courts and authorities, and instead of liquidator or instead of the corporate debtor, the assignee would get his own name replaced, and he would become then the respondent, or he would become the applicant in all those applications wherever those applications are pending. So this is the process, and in case of any difficulty, we can actually go and finally ask the adjudicating authority. So this is that judgment in which I was referring to, Alchemist Asset Reconstruction Company Limited versus Moser Bayer, where the application was made to adjudicating authority, and adjudicating authority allowed. This was an order dated 31st of March 2021, and the assets, it was simply directed, yes, the liquidator can go ahead after going through the transparent process. Now let us understand the different models of assignment. This is where the new concept I am trying to introduce. I would actually be suggesting that please focus, and then we will take up the questions. Of course, the time will still be permitting us to take up the questions. Now, the different models of the assignments can be: number one, the total price is fixed, net of all expenses. Entire amount is paid by the bidder, and all the assets are assigned with no future reference of monitoring, etc. The distribution is made to the stakeholders, and the company is dissolved. This is the first model, which is very easy, and that is only possible in case we get a customer to buy these assets. Now, in case we don't get such customers, then the second model can be: the total price is fixed, net of all expenses. Net of all expenses means, when I say that, means that all litigation expenses, all recovery cost, partly it is paid on the assignment, and then the balance to be paid later in installments or on the recovery from the assets or on a fixed duration period. The distribution pattern would become part of the assignment agreement, and the assignee would be under obligation to pay that money to the stakeholders as per the distribution pattern, which is mentioned in the assignment agreement. So this is a second model where the company is dissolved. There is one assignee who has paid partly, and the balance he has committed that the balance amount will be paid in this manner. And whenever he will pay to the stakeholders as mentioned in the assignment agreement. So this is a second model. And we may get some customers who are actually ready to who are ready, depending upon the nature of the customers, who are ready to put a value, for the disputed asset, and that value is also acceptable to or with the consent of the SEC, then this second model will work. So in case we still don't get any customer on this, then let us go to the third model. Total price is fixed for net of all expenses for all these disputes, NRRA, partly paid on assignment and part to be paid on actual realization. So the second model was that the second part of the money was to be paid on installments. Now the third model is that the balance amount to be paid on the actual realization. If that is agreeable, the assignment agreement will mention all this, and the distribution pattern to the stakeholder is crystallized in the agreement, and the assignee will have the responsibility to realize. He will incur all the expenditure, and whenever the money is realized, he would distribute it to the stakeholders. However, the liquidator has already filed an application for dissolution, since as some of the assets are sold and some of the assets are assigned, so there is nothing left, so the company is dissolved. Now the other fourth model of assignment under Regulation 37A. Nobody comes for fixed price because of various uncertainties of time, various uncertainties of realization, and also the expenditure. Then an agreement can be reached where a percentage to be distributed to the stakeholders on realization net of expenditure. For example, the agreement can say that whatever would be realized by the assignee, 75% or 50% will be paid to the stakeholder, depending upon the negotiation, depending upon the nature of assets. Then in that case, all the expenditures to be borne by the bidder, and balance to be paid. He can definitely pay whenever he is realizing. He will retain his own profit, and he can pay the balance to the stakeholders. There can be further negotiation that the assignee may ask that as the liquidator normally keeps some money for litigation, the assignee should also be given some money for handling litigation. That also can be agreeable by the stakeholders, because for the stakeholders, even the liquidator is also keeping some money with the liquidator for future expenditure. The last option, the last model is no price is fixed. Assets are assigned to an agency on a remuneration, maybe monthly remuneration or a percentage remuneration, with or without expenditure. So that model can be that the remuneration and plus whatever actual expenditures are incurred by the agency will retain the remuneration and the expenditure, and whatever is recovered, that would be distributed to the stakeholders. So in case we are not able to get any of these earlier models, so this fifth model may work. And see, what are the first options with the stakeholders consultation committee is that the liquidator continues. Liquidator will hold some amount, few lakhs of rupees for the future litigation, and the liquidator will keep on reporting every quarter, and liquidator will keep spending on the litigation and keep spending on the quarterly reports, etc., and also the audit every year. So that is one option with the stakeholders, and the stakeholders also will keep participating into the stakeholders consultation committee meetings. Second option can be that the company may be dissolved and all the assets may be assigned to another agency, and that another agency on a remuneration, as the liquidator is also taking remuneration, on a remuneration or on a sharing model, and that agency would distribute to the stakeholders on the realization of the asset after keeping his own per month fee and success fee. Now the last option, which very sensitive to discuss, is that the assignment of these assets can be made to a related party of the liquidator. Assignment of these assets can be made to a related party of the liquidator. For the stakeholders, for the adjudicating authority, it is the liquidator who is presently being trusted. There is only one difference, that the liquidator is under monitor, liquidator is under regulator, whereas that related party may not be under any regulator. The assets are assigned to that related party. There is no fixed price for the assets. Again, remuneration. Some money can be retained by the related party. Assets would be realized. Assets would be realized, and proper accounts would be given. And permission of the adjudicating authority is required in this particular model. Only in this model, the permission of the adjudicating authority is required, and the assignment agreement. Assignment agreement should provide that the assignee agency will hold, for example, for an illustration, will hold stakeholders consultation committee meetings every quarter. The agency will provide updates every month or every quarter. The agency will provide account of all expenditure or all incomes recovered, and the agency will do this, and the agency will do this. That kind of assignment agreement, that would be valid, and that can be the last resort in case really there is nobody coming. And for SCC, it doesn't make any difference, either the liquidator continues or a related party continues. However, for the liquidator, it makes sense. Adjudicating authority would accept this kind of scenario, because even the liquidator was getting a remuneration. If the liquidator is not getting a remuneration, his related party can get some remuneration. And this also may get approval from adjudicating authority. So in case the approval, because why I'm saying so, because I have to read this regulation 33 of the liquidation process. Sale by means of a private sale. The liquidator shall ordinarily sell the assets of the corporate debtor through an auction in the manner specified in Schedule 1, which is e-auction. The liquidator may sell the assets of the corporate debtor by means of private sale in the manner specified in Schedule 1 when the assets are perishable, assets is likely to be deteriorating, assets is sold in a price higher than reserve price. And fourth is the permission of the adjudicating authority has been obtained for such sale. Provided that the liquidator shall not sell the assets without prior permission of the adjudicating authority by way of private sale to a related party of the corporate debtor, his related party, or any professional appointed by him. So therefore, what I'm trying to say is that Regulation 33 provides that the adjudicating authority can approve sale of assets to a related party of the liquidator or to any professional appointed by the liquidator. This particular regulation permits that. Adjudicating authority would see whether it is conflicting or whether it actually would be in the interest of stakeholders. But in case the stakeholders are also agreeing, then the adjudicating authority might say that the stakeholders are not perceiving any difference between the liquidator or any of the related party of the liquidator. When we actually come to the assignment of debt under section, the assignment of the debt, the assignment is dealt by section 37 of Indian Contract Act 1872, and it is also dealt by section 130 of the Transfer of Properties Act. So whenever it is intangible assets like contractual rights, benefits, etc., corporeal like real and physical assets are transferred, the concept of change of hands. So any actionable claims are covered under section 130 of the Transfer of Properties Act. The debtor is not a party to the transaction and his consent is not required for its validity. However, there can be some disputes. However, in our cases, the debtor will not give consent. So these are the rights of the assigner. There are assignments which are being done under SARFAESI Act that we all know. The total debt is assigned to asset reconstruction companies under SARFAESI Act. So in this particular case, the assignment would be done under Regulation 37A. Once assigned, the assignee shall not be able to take benefit of the powers of the liquidator, and also the jurisdiction of NCLT would not be available to the assignee. So I think what we are trying to say is that assets that may or may not, I'm trying to talk about some of the intangible assets which actually may be covered under Regulation 37A. Assets that may or may not be in possession of the corporate debtor, including but not limited to encumbered assets, assets forming part of the liquidation. So the following assets, for some examples, So in this case, the first assumption is section 36, like the liquidation estate section says, the first assumption is that the asset is owned by the company. And the second illustration is that the asset for which the possession is handed over to third parties, like assets leased to third parties, pledge of stock to third parties, asset loaned to third parties. So these are all assets which are forming part of the liquidation estate. Then we are also talking about the assets where the possession is handed over as part performance of the contract under section 53A of the Transfer of Properties Act. We are also talking about the assets sold on power of attorney and agreements to sell basis with possession and almost full consideration is passed. So these are some of the critical issues which in the liquidation estate we are handling. Assets given to third parties on financial lease and the other party has almost paid substantial cost of assets, contractual rights of the third parties to be protected. So these are all, I'm trying to figure out the various critical issues that we are handling in the liquidation process. I'm not going in detail, but these critical issues are in fact many. I think that we can take up some of the questions because the critical issues, of course, finally, we are trying to say that these critical issues are there. There are disputed assets. No liquidation process can be closed. No liquidation process can be closed without even having the NRRA. So my presentation is finished. I think we have substantial time for questions. There is some background noise coming. So I think the questions, if there are any, then we can understand that. Now, see, one of the questions which is coming to me is how the PUFE transaction, can be handled. Before this regulation 37A, at times we thought that the PUFE transaction is also a contingent asset, and we can even distribute this asset to one of the stakeholder with an agreement that whatever would be recovered, that would be allocated to the stakeholders as per the predetermined pattern. But now the PUFE transactions can also be part of this NRRA, and whatever would be the recovery may take 3 years, 4 years, because see, in PUFE transactions, in case you get any order against any preferential creditor or any transferee of asset or any contribution from the promoters, all that is a contingency, all that is an asset, and it can be part of this NRRA and can be assigned to an agency. We as the AAA Legal Professionals LLP, we have started taking over assets on remuneration plus recovery basis, and this model will start functioning because see, this needs a lot of legal force. So anyone who has legal force can certainly work on these kind of transactions where NRRA can be taken over on assignment basis, and whenever the recovery is made, that can be distributed to the stakeholders. I'm sure the uncertainties are huge. The possibilities of getting fixed price is not there in many cases. In 90% of the cases, that possibility would not be there. So what we are trying to say that it is only and only possible that we are assigning. Actually, there is another question which.
Yes, so there is one question I'd like to tell you.
Yes, please. Yes, please.
Basically, in case where under section 52, a creditor do not relinquish his security to the liquidation state. Now, there is no time limit provided in the regulation or the code for selling that particular asset. So, if that sales doesn't happen, so then how the dissolution will be completed? Then whether is it liquidator can take back that asset which has not been relinquished or not been sold back to his liquidation estate? Then how do we proceed? This is the question from one of our attendees.
No, see, like there was a regulation in the liquidation process regulations, Jitendra, and that regulation was kind of it was a regulation. I think it was no, there is a regulation which now controls, like if a particular asset is regulation 21A. So the relinquishment of an asset, if the asset is not relinquished, and then it has to be sold. Now, so the question is like, if there is there are two possibilities, Jitinder. One possibility is that the liquidation value of the asset is more than the claim of the creditor. Then that there is a regulation that the creditor has to sell that asset within a stipulated period, and whatever he recover, he will retain his own claim, and the balance he will pass on to liquidator. Second possibility is that the asset which is not relinquished in favor of the liquidation estate is having a value which is perceived value, but the asset is not sold. Then within 180 days, that financial creditor will have to pay the difference to the liquidator. So there are provisions. So it is not something which is not provided for. There is a complete regulation about this.
Right. So we have, sir, one question is there. As you said that a liquidator can keep certain amount in his account for future liquidation and future litigation actually. Yes. And even after dissolution, what I presume is what you said. So how
I'm saying there are two issues. One is that whenever we distribute to stakeholders, Jitinderji, we keep some money with us for future expenditure. Now, I'm saying the second model is that in the case of assignment under Regulation 37A for NRRA, then the stakeholders consultation committee can also say that we are appointing an agency, and that agency can also be given some amount as we could have given to the liquidator, and the agency will incur expenditure out of this deposit, and after all this litigation, all these assets are realized, then a complete account would be provided by that agency. So I'm not saying that the liquidator can keep that amount. I'm not saying that. The liquidator cannot keep that amount because the liquidator, in fact, I wanted to say the related party to the liquidator after taking permission from the adjudicating authority. So in case adjudicating authority gives a permission, which is provided in Regulation 33, then the stakeholders consultation committee, adjudicating authority, then it doesn't, there is no non-compliance to any part of law. Then any of the agency of the liquidator, any of the related party of the liquidator can continue the process of realization. However, the liquidation assignment is complete, the company is dissolved.
So now there is one question from Mr. Vimal Narora. Assets sold by the CD on which lenders are claiming mortgages, but assets are not in the books as they sold much before CIRP or liquidation. Such asset on the extent of mortgage is available for sale by liquidator. I presume no, but yes, please clarify.
See, there are many assets, like mostly lenders are claiming that they have lien on 100 crores of stock. When the liquidator reaches the factory, there is no stock available there. So if there is no stock available, the liquidator will depend upon the physical inventory. Liquidator will not depend upon the actual mortgaged assets. In case there is no asset available, so the liquidator would say that your security interest is already lost.
Yeah, there is one question that is there a possibility of getting refund of MAT credit from the income tax department by a voluntary liquidating company?
No, voluntary liquidating company it definitely can recover all their dues. Voluntary liquidation company, the section 53 is not applicable to voluntary liquidating companies. The voluntary liquidating company will comply with everything. Whatever assets are outstanding, that assets would be recovered and would be distributed. The voluntary liquidator has all the rights to recover. Even the liquidator has all the rights to recover refunds or GST refund or income tax refund. All these are assets of the liquidation estate, part of the liquidation estate.
but there is no provision in the income tax for granting the refund of MAT credit. So we have
no refund of MAT credit. Refund of MAT credit is not possible. Like in no circumstances the refund of MAT credit is available.
Yes, that is what the query was.
No, MAT credit is not not possible. So there was one question I was reading, what is NRRA? So this is something which is not readily realizable asset as per regulation 37A inserted in the liquidation process regulations on 13th of October 2020.
So what is your view actually regarding, what is your view regarding the payment of the PF department and ESI department dues actually? Either on the liquidation and distribution of the asset, whether you see there has been a numerous judgment by the Supreme Court and CLAT, which now says that it has a super priority over every dues. Even if there is no fund, you have to pay the PF dues and ESI dues along with the interest and penalty.
No, this is a very interesting subject. In fact, I have already started preparing my next subject, and that subject is the labor law as applicable during CIRP or liquidation. So the one important aspect is the section 36, subsection 4. So I think somebody has to just keep it mute. Maybe
Sumit, your background is actually disturbing, Sumit. Please, if you can check it out.
So like when we see this liquidation estate section 36 subsection 4, I think subclause C, which says that any amount in provident fund, superannuation fund or gratuity fund that would not be part of the liquidation estate of the corporate debtor. So there was a first judgment which was given by Honorable Justice Mukhopadhyay, and in that judgment, that was in the case of Moser Bear versus the Workmen Association. In that particular order, it was held that the provident fund, gratuity fund, and superannuation fund, if there is anything which is payable, that will be paid out of the assets of the company, and that will be having top priority, and that would actually have the priority beyond section 53. Even the liquidation cost or CIRP cost will be after that, because that particular money would not be considered as money belonging to the company. That would be considered as money belonging to third parties, where the liquidation, it will not be part of the liquidation estate. So the third party in that case would be considered to be workman. So that money will go there. So that particular judgment was applied in various other cases. Then came another judgment, that was Saman Godiwala, and that was in the case of Lanco Infra. That was also from ANCLAD. In this particular judgment, it was very clearly said that these three funds which are being talked about under regulation and under section 36, subsection 4 and clause C, these are talking about if these funds are, if there is a money, see, like it actually takes, there is a situation where these funds are maintained by some companies. These funds are maintained by some companies, and these funds are also kept in the balance sheet of the company, or maybe outside the balance sheet of the company. So it is clarified in that order of Saman Godiwala in the case of Lanco Infra that if there are these funds and if there is a money available in these funds will not form a part of liquidation estate, and these funds will be directly paid to the person it belongs to. So after that ANCLAD judgment, there is no further order on this from Supreme Court or from any other, even from ANCLAD also. ANCLAD also confirmed in one more order that this is what is the meaning of section 36, subsection 4, clause C. So now the scenario is that after this judgment, if there is any provident fund dues, so there are two types of provident fund dues. Let us talk about provident fund dues. Provident fund dues are the company is making payment to the Commissioner of Provident Fund, and the amount is due to be paid to the Commissioner of Provident Fund only on the payment of salary. If no salary is paid, the Provident Fund is not required to be deposited. If salary is paid, the employer contribution is supposed to be deposited and employee contribution is also supposed to be deposited. That is what is the amount which is supposed to be deposited to Provident Fund. Now the Provident Fund Commissioner would have some information that the salaries are distributed, but the amount is not being paid to the Provident Fund Commissioner. So that amount which is due to be paid to the Provident Fund Commissioner, that would be considered as workman's dues or employee's dues, and those can be considered as workman dues. So the Provident Fund is not a statutory authority. It is not the amount which is paid to the consolidated fund of a state or consolidated fund of India. So these are not statutory authorities. Provident Fund is an organization which keeps the money on behalf of the workmen, and if no money is given to the Commissioner Provident Fund, then that remains as workman dues, and that would be considered as workman dues under Section 53. So this is regarding Provident Fund. Is there any other?
Yeah. Sumit ji wanted to speak something. Sumit ji.
Hello.
Yeah, Sumit ji, please.
My simple question was that if a company is under liquidation and it has got wholly owned subsidiaries, where practically there is nothing, just financial assets are there, which has got practically no value, and it is basically cross investments into other associate companies of the same group. How do we handle that situation? Because it is NRRA, nobody would ever say that.
I think, as I said, that these, first of all, there will be no valuation for these shares as per the valuation report. As a liquidator, we actually have to sell the assets. Correct. And the reserve price would be as per the valuation report. So the reserve price is nil. If an asset is having reserve price as nil, there is an option that you can always say that we write off these investments and we file a dissolution application to adjudicating authority, that giving justification that there is no value, so we write off these investments. Second possibility is that we actually assign it under Regulation 37A. Since now this regulation is available, I think the adjudicating authority would be very hesitantly accept writing off the assets. Otherwise, it can be a very big dispute, because I have companies where the outstanding book debts are 500 crore, but recoverables are nil. So I don't think the adjudicating authority will accept that, yes, I accept that everything is written off. They would not accept the dissolution. So therefore, since now we have Regulation 37A, the AAA would probably insist that you assign it to someone.
But I don't think that there would be any takers.
So
can't there be a non-fund?
But Sumit bhai, like,
I think
the liquidation has to be closed. The liquidation has to be closed.
No, the non-fund
liquidation.
Yeah, absolutely. But no, I think there is a suggestion that we should write to the Insolvency and Bankruptcy Board of India to create a fund for non-fund assets. Like, there is a fund wherein if nothing is being claimed, it is being transferred to the consolidated fund maintained by Insolvency Bankruptcy Board of India. So non-cash assets wherein there are no takers, there should be some mechanism or some body. I don't know. It's a long process, but
the mechanism I think the mechanism that they brought as 37A, I think that's what is in their mind. If somebody is not ready to pay upfront, then maybe, because Sumit, in some of the resolution plans also, we actually approve resolution plans where the RA says that out of the total bank guarantees, if I will save invocation, then the creditors will give him some reward, or out of some arbitration cases, whatever he recover, he will give, say, 50% to the creditors. These kind of resolution plans are being approved. Similarly, in liquidation also, if the assets are assigned to someone with these conditions, with these kind of monitoring also, the adjudicating authority would approve it, or even the SEC would give consent, because the SEC would not continue with the liquidation assignment for years. How can you sustain in this profession? If I have 10 cases of liquidation, and in all the 10 cases, litigations are going on, and the litigations are taking its own time, the avoidance transactions will take 3 years, 4 years, 5 years, if there is an order, and then everyone, either party will go in appeal. So all these decisions will go
Correct.
to Supreme Court. So how can I continue with my profession in case all this is not assigned to someone, and I'm free to take few fresh assignments? So this has to be done. And in case the SEC doesn't agree, then I would be compelled to file an application to adjudicating authority that this is something, that issue is there, and I need to get rid. And I'm not saying that any additional remuneration. Only thing is that this particular agency is taking over from me, and as I would have taken the fee, this agency will also take the same fee. How can you say no? The only reason that somebody can say no is, as an outside agency, that particular agency is not under the regulator. However, the liquidator is under the regulator. With this difference, the liquidator should not suffer. The liquidator cannot continue with the assignments where some litigation or arbitration is going on, or you accept write-off. So if you are not accepting write-off, then you have to give me some leave.
Correct. So we'll take one last question from CAKS Ramesh. Mr. Ramesh, you can unmute yourself and.
Yeah, thank you. Many questions are there. Many clarifications, but very simple clarifications. I sold a flat in Kolkata, and due to COVID, the buyer is insisting on a sale deed. So I cannot go and execute the sale deed. Can I give a power of attorney as a liquidator? And secondly, yes, when you have agreed, one more question. When you agreed that Provident Fund gratuity have become priority without link to Section 53, when is the timing? Is the liquidator obligated to, suppose liquidation commencement date is today, and are we obligated to pay to the workers tomorrow without waiting for 53 distribution schedule?
No, see, it all depends. The first question is like yes, the liquidator can give power of attorney, a registered power of attorney for registration of any sale deed in favor of the buyer. Right. There are 2-3 difficulties that I faced. One, that in Delhi, I have to go to get a registered power of attorney, and that person who, see, like in Delhi, it is not required that the beneficiary of the power of attorney is not required to be present in the registrar's office. Okay. So I did this, and then finally in Bombay, that particular power of attorney was not accepted. The Bombay registrar said that the power of attorney holder was not there in the picture while the registration of power of attorney was being done. Second time, we did the other way, and the power of attorney holder was also available in the picture, so it was accepted by the registrar in Mumbai. So this is question number 1. Second is, the workman dues are supposed to be paid after liquidation, and after liquidation cost and after CIRP cost, and also in proportion. Like if the total claim from the financial creditors are 100, and they are getting 10% today, and the total claim from the workman is only 5, they will also get 10%. So this is what Section 53 says. Whatever percentage is being given to secured financial creditor, the same percentage will be given to workmen against their dues. So there is no time limit. As and when the funds are available, the secured creditor and workman, they would be given money at the same time.
But gratuity is not forming part of liquidation estate. That's why they said it is outside 53 upfront.
No. I think again I will clarify. So I've already said that the gratuity fund, which is mentioned in Section 36, subsection 4, clause C, that talks about the fund if it is maintained by the company, and there is money in that. So in case there is no such fund maintained by the company, or there is no money in that, so gratuity claim of a workman would be considered as gratuity only. So that would be considered as gratuity claim, that will be part of the workman's dues. So it is nowhere mentioned that I have seen so far that the gratuity would be paid in full, whereas the wages will be paid in pari passu arrangement with the secured creditors. I'm only trying to say with let us understand, if a fully compliant company would want that it will be creating a reserve, it will be creating a provision for gratuity. But that provision doesn't mean that it is backed by assets. Now, if a company is having LIC insurance and all that, then whatever gratuity would be, that would be handled by the LIC insurance whenever that is eligible. Now, in case there is a provision created in the balance sheet, but there is no corresponding funds available, then the gratuity claim will come to the RP. I'm saying so why it is very important, because if a company is taken over by another management, and that another management should not be responsible for the entire gratuity payment of the company. So the gratuity claim also will be taken as on the date of CIRP and also as on the date of liquidation. And that would be considered as workman dues and will be paid as per section 53 or whatever is proposed in the resolution plan.
Thank you. Thank you.
I think with this, every good thing must come to an end. So the questions, I know, there would be many questions on this topic. It's very practical. We are day in and out dealing with all the practical issues, and we might not have right now the answers to all the questions. But yes, as and when the issues comes up, Anil sir has always been there with us in responding to us and giving solution to our queries, and I think he will always be there with us in helping us in carrying out this assignment. So with this, I would request, and sir, one last question just came to my mind, that how do we sell the listed shares actually during the liquidation? Because listed share cannot be done, no auction can be done. So should we go to AA that we want to sell the listed shares through the off-market, through the on-market platform?
So we have sold listed shares many times. First of all, the RP or the liquidator will replace his own name in the demat account, and then if it is a listed shares, then the broker would be asked to sell the shares at a market price. So for the purpose of listed shares, the stock exchange is the complete transparent platform. So there is no requirement of reserve price. There is no requirement of e-auction. Simply, it will be sold by the broker and the money can be kept in the liquidation account of the company.
Right. Thank you. When just this question came to last minute in my mind, so I thought that let us take the opportunity of clearing this question while you are there. So with this, thank you, Anil sir, for joining with us. And I would now request Hina Jajodia to formally offer a vote of thanks to our eminent speaker.
Thank you, Anil. Thank you very much for joining.
Thank you, Jitendra ji.
Anything you want to add, Sumit ji?
No. I was just wanting to personally thank Anil ji for accepting our request.
And it's all your
Sumit bhai, one last word, Sumit ji. I would say that the regulation 37A has to be used. All of us try to use it. We must present before SEC. We must present before adjudicating authority. Otherwise, this will actually become something which is a kind of headache for all of us. If you collect liquidation cases and you would be out of profession, you actually have to dispose of the cases. You have to dissolve the companies. So all of us must do the effort of using 37A on a whenever recovered, money will be payable to the stakeholders.
Absolutely.
On that model.
Absolutely.
Thank you. Feeling highly privileged to convey regards to Anil sir. Deliberation of Anil sir was highly illuminating. IP has to face a lot of challenges during liquidation. Generally, it becomes difficult to dissolve the CD during the prescribed time frame. Sir, you have pointed to use 37A for faster closure. You have spoken on different modes of assignments very nicely, and all of our queries has been answered in a very excellent manner. Sir, your splendid deliberation will be highly beneficial for all of us. Thank you, sir, for sharing your valuable knowledge. On behalf of ACAE, we are offering a virtual memento as a token of honor.
Thank you. Thank you very much.
Thank you, sir. Thank you. Thanks a lot for joining and for this wonderful session.
Thank you very much. The ACAE Chartered Accountant Study Circle, and thanks a lot to Sumit Bhai, to the convener Vivek Agarwal, and to all the functionaries, and most important is the participants, more than 500. It is definitely overwhelming for us. Thank you. Thank you.
Thank you. Again, I'd like to thank each and every participant for making today's program a grand success. Thank you, everyone.
Thank you.
Thank you.